Good afternoon, everybody. My name is Patricia Aaliyah. I'm from Aaliyah Associates, and thank you for joining us for CondoWise Learning Series. We're just waiting for people to come into our meeting room. But today I wanted to tell you a little bit about what we are going to have our guest speaker, who is Richard Aaliyah, speaking about. The collection process is a complicated legal process, and oftentimes it doesn't get enough attention. So today, Richard is actually going to break it down for us and help us understand it better so we can proactively manage it. Today, our speakers are, next slide, please. Jonathan Wright, in addition to Richard, Victor Yee, and Shannon Penny. So without further delay, I'm going to turn this over now to Shannon for our pandemic update. Shannon?
Perfect. Thank you very much, Patricia. So hello, everyone. So as we all know, Ontario is under a stay-at-home order, which requires everyone to remain at home with the exceptions only for essential purposes. So these measures are in effect for all of Ontario and expected to remain in place until at least May 20th. There's been no announcement as of yet as to whether this will be extended. So yesterday, Health Canada also cleared children aged 12 and older to receive the Pfizer vaccine. Also, as of Monday, May 3rd, the Government of Ontario expanded its COVID-19 vaccine eligibility, opening the provincial booking portal to hotspot residents aged 18 and older. Adults living in the specific postal codes that designated as hotspots were able to start reserving appointments as of Monday morning. Certain regions are also offering pop-up clinics for those aged 18 and older, living or working in hotspot postal codes. No appointments are necessary. You can visit our website for a recent bulletin that includes a list of the pop-up clinics in the Toronto area this week. So each region has different eligibility, and it's important that you keep up to date with this information just to ensure that you're able to receive your vaccine as soon as you become eligible. Adults aged 50 and older across Ontario are among the new groups who can book a vaccine appointment starting today. Bear in mind, those aged 40 and older also have the option of booking their AstraZeneca vaccine at select pharmacies and some primary care providers. So Peel Region have also launched a vaccine standby list. This allows residents to take advantage of leftover doses at the COVID-19 clinics. Officials confirmed that they'll allow up to around 300 people a week to put their names on the list. The list will then be cleared every Sunday evening, at which point residents within the Peel region can try to sign up again. Peel also announced this morning that it will be offering vaccines to all residents aged 18 and older, not just those living in the hotspot neighbourhoods. So board members and property managers are encouraged to share this information with their communities. It's important that during this crucial time, we all come together to protect one another. We understand that the elderly within the community may have some difficulties with the online booking system and are encouraged to reach out for help. It's also important that they are aware that you can also make the appointments via the telephone. So I'll now pass you over to Richard Aaliyah, who's going to be discussing the common expense collection process. Thank you.
Thanks, Shannon. If there's any glitches with the slides, that's me, the guest speaker, and they put me in control of the remote. I guess it's a guy thing, I don't know. Anyway, we're going to do common expense collections right now, and we're going to start with a panel puzzler. And I just want to throw out there the question, when is it appropriate to write off common expenses? Is it never? Is it when they go unpaid and you can't do it through the lien? Or is it when a challenge to the lien arises? So what do you guys think?
I'm going to say never.
Never.
What did you say, John?
Also, I'd agree, never appropriate.
Victor?
I'd say depends. That's the lawyer's answer right there.
Yeah.
Shannon?
Also say never.
Okay.
Okay.
For those regular common expenses, the ones that are, you do the annual budget, you send, you do the calculation pursuant to the proportionate allocation, it should be never. You never have to write off. And yet, year after year, we go to AGMs and we hear the auditor say to the ownership, this year we're writing off so and so. Thank God it doesn't happen all the time. It is fairly rare. I think the one that always stands out for me is when the auditor stood up and said we're writing off $45,000 of common expenses. And I immediately asked who was doing their collections because it wasn't us. The standard seems at times like it's perfection, but it's not. But there's no reason why we can't strive for that. It's not. This isn't rocket science, but it's got to be recognized as a legal process. The process has to be pursuant to the Act. It's got to be efficient. It's got to be consistent, and you have to really think where are those areas of conflict that are going to arise. And with areas of I'm going to be getting into this in a bit, but think about the rest of the community. Think about the third parties out there. Anyone who has an interest in this process. Should be recognized. Responsibility, some might not like this. I'm going to say responsibility at the outset lies with whoever's keeping the books. Typically if you got professional property management, typically this is property management, because we've got to be able to rely on the accuracy of the bookkeeping. The unit ledger's got to reflect properly the regular common expenses as they come due, special assessments, the chargebacks. And especially with assessments and chargebacks, they've got to be documented, they've got to be explained and recorded properly. We'll get into that more. And as we go through today, I'm going to be going through and touching on what's the big deal about the lien, and it is a big deal. What amounts are subject to the lien chargebacks? That's been a big hot topic item of late. Victor's going to be getting into that. Timeline for lien perfection, the legal process with respect to all parties, and then any questions that you might have. We've got some pre-prepared, which come up a lot, and you may have others. So let's start with what is a lien. And if we want to start with what is a lien, we have to first understand what are common expenses. And common expenses it's a defined term in the Act. And if you look at Section 1, these are expenses related to the performance of the objects and duties of your corporation. This is your cash flow or your tax dollars. You can't operate your condo without money, without cash, and this is how you get it. There's nothing else. You don't sell anything. You don't sell a service or anything. This is it. And when an owner buys into a condo, they're buying into an obligation to pay taxes. It's no different than you go and buy a house, you're paying property tax on that property. No different. So what is the lien then? Well, the lien, I think everyone knows this. It's a security of a debt. It's in this case, very similar to a mortgage, and it's enforceable as a mortgage. When we think about the condominium lien, it's a whole mechanism that allows for the very efficient collection of these common expenses. I do want to stress that a condo lien does not arise 3 months after the arrears start. The condo lien starts immediately. Again, there's a timeline which I'm going to go through. So as soon as somebody doesn't pay, day one, or I guess day two, they don't pay, the lien is there. It's statutory, it's automatic. If you have to fill out a status certificate, you put the owner is in arrears, but no lien has been registered. Doesn't mean the lien doesn't exist. It does exist. And why is this? I'm sure jumping to my next slide a little bit. Why is it so important? Why is the lien so important? Why do we care? Because of what's called super priority. And super priority is it allows the lien to jump the queue. When we think about creditors lining up, if someone's got money problems, there's usually an order to it. And very typically it's the order of registration. If it's a registered security order as they come up, a condo lien jumps the queue. And where does it jump? It jumps right to the beginning, well, almost the beginning, right after government. So very effective. It actually puts the bank's mortgage in default. That's right in the Act. It's in mortgage documents, and it's a remarkable tool if it's used right. I just want to jump back to that last slide. Something I didn't catch. It's not an investment tool. I want to stress this because this comes up. Interest is very high, typically 18 to 24%, and that it's set that way because it's a deterrent against non-payment. It's not, condos cannot lend money. So what we want people to do is, some people might be looking at their, you got a credit card statement and you got your, the reminder letter from the condo. We want the condo's common expenses to be paid first. And the courts have upheld 18 to 20%, but it's not an investment tool. Great return, but not an investment tool. Okay. So I mentioned owners buy in, they've got an obligation to pay common expenses. So the question, I was actually on the phone with a manager this morning who says, I've got somebody who's refusing to pay the cable TV portion of their common expenses. They got bulk cable TV. Too bad, so sad. You're paying that. And that issue's actually gone to court. We took that question to court about 15 years back. And because we had an owner who was carving out the cable TV portion. We eventually had to lien the unit and enforce on the lien, and it ended up in court, and the court agreed you can't avoid it. There is no avoidance. If you want to waive or abandon your right to use something, again, too bad. This is part of living in that community. When you think in a high rise, the family on the first floor basically doesn't use the elevator, but they still have to pay. The one, the first floor also doesn't make much use of the roof, still has to pay. It doesn't matter if you have a parking unit, but you don't own a car, you still have to pay. That's how condos work. Now, if an owner's got a claim against the condo, again, doesn't matter, you still have to pay. So an owner's saying, I'm not going to pay my common expenses until you fix my front walkway. It doesn't work that way. That owner will be liened. And then lastly, declaration, some bylaws rules sometimes restrict an owner from using the common elements. The logical ones are, the management office is typically restricted, access to the roofs are restricted, things like that. Sometimes you'll see the owner that leases their unit cannot make use of facilities. Again, too bad, there's no avoidance. And this is right out of the Act, Section 84, sub 3. So what amounts are subject to the lien? And this is getting a little bit tighter because it's not everything. So we start off with budgeted common expenses or special assessments. Again, every year the board has to come up with their budget, and they send out notice to the owners, and typically the notice will say to each owner how much you have to pay each month. And this is calculated pursuant to that proportionate allocation in the declaration, typically Schedule D. If you're in a really old condo, something from the early 70s, chances are it is not in Schedule D, but by 1980, it was pretty standardized. So if you're leaning for non-payment of those regular common expenses, reasonable legal costs and reasonable expenses relating to the litigation are secured under that lien. And later, John's going to be telling us about a recent case, which is on reasonableness of legal costs. And then we've got late payment interest. And again, the courts have upheld that 24%. Sometimes we see late payment charges, $50 a month, just tack it on, boom, boom, boom. I'm really hesitant on that because it's not interest. It may not be an expense relating to collection. It's just more in the nature of a fine. And you really got to be careful with that because that may not be recoverable. And frankly, with high interest rate, you don't need that if it's going to serve as a deterrent. Where you can add fees is if there is actual work involved. If management is sending, sending an updated ledger, why not bill for that time? There's nothing wrong with that, but it should be a cost incurred. Okay, second panel puzzler. Chargebacks, to charge back legal costs. Now these are those, how many times do we get asked, let's send out a compliance letter, cease and desist letter, whatever. And invariably it comes to the instructions, charge back the owner for your fees. And I often cringe at those instructions. If we're going to charge it back, if the chargeback is going to be lienable, where do we find the authority? Is it the rules, the bylaws, declaration, and the act? None of the above, all of the above. What do you guys think?
John?
Anyone?
Act, declaration, bylaws?
Act and declaration,
Yeah,
not
I would
bylaws.
agree. You start there for sure.
What about an insurance deductible bylaw will give you the ability to charge back the insurance deductible?
Could
That's
you
under the
mention-
act.
That's under the act.
Can also be in a
The
bylaw though.
The act is what grounds the bylaw, right? Yeah.
Fair. I'll
That's a
give you that.
safe bet. We'll start with the act.
So typically it's declaration and act, and typical litigator is going to split hairs there. So under the act, we've got insurance deductible, which John brought up, and yes, there is the bylaw to expand the circumstances for recovery. But where the authority for the lien is coming from is section 105 sub 2 and sub 3, and that's right out of the act. We got legal costs on if you're going after and get a compliance order, 134 sub 5, unit maintenance and repair, 92 sub 4, unit alterations or alteration agreement enforcement, so section 98 agreements, 98 sub 4, occupancy standards costs, section 57. These are all lienable from the act. It's not carte blanche, but it's all lienable from the act. Now, the declaration may be, and I'm going to get back to that. Bylaws right now, no. Rules, no. Creative, i.e. fines, no. Bylaws, the issue of bylaws went to court back in, I think it was sometime in the early 90s. I think the case was Basmagian, if I'm not mistaken. And in that case, the court said no. And that case actually said you had to find the authority only in the act, and that's been expanded. The creative ones like fines, that's always been no. And the logic for no is how are you going to enforce it? You fine somebody $50 for not scooping after the dog poops. How are you going to enforce that? You're not going to register a lien for a $50 fine, and it's illegal anyway. It wouldn't be upheld, and then you're going to lose all credibility. So just don't do it.
Just to clarify, you said it's illegal to do it. You mean to charge a fine? Is that right?
Okay. There's nothing in the act that speaks to it, or there didn't used to be. Now the act says you can't lien for it. But historically, there hasn't been a way to actually enforce it. And this was up to some debate when the amendment to the act that came out in 2017, November 2017. There was a lot of debate in the 5 years leading up to that about whether condos should be allowed to fine. I was on the side that said yes, they should be allowed to fine. Condos are mini municipalities. They need the tools of municipalities in order to operate. A municipality can issue parking tickets. Why can't a condo?
So what if there's a cost to cleaning up?
Well, then that's different. That can be charged back. Oh, well, actually, we're going to let Victor speak to that one.
Okay.
And just to lead into Victor's comment, I just want to mention one case which we've all been hanging our hats on for a long time, 2008 decision, Italiano and TSCC 1507. This is pre-Amlani, because we have to always recognize the Amlani effect right now, pre-Amlani. And what the court said there was, if you find the authority in the act or the deck, you can lien. Fabulous decision. Victor, what's the Amlani effect?
So the Amlani effect is due to a case from last year called, basically we're just going to shorthand it as Amlani. So Mr. Amlani was a smoker who smoked inside his condo. The condo passed a no smoking rule after he bought the unit and moved in, and he was smoking for several years before that. And then the condo's lawyers tried to enforce that rule against him and charge back the legal costs of that enforcement to his common expenses. And so the Superior Court said, no, you can't do that in this situation, because at that specific condo's declaration's wording for the indemnity was a limited indemnity clause. So it basically said that you can only charge back if those costs are to or with respect to the common elements or all other units. So that's usually in the case of floods or fires or something physical that damages the units around you or the common elements around you. So the court in that case, in the Amlani case, said, in this specific situation, this guy is just smoking. He's not causing any physical damage. There was no allegation of, yellow smoke damage on the walls or whatever. He was just breaking a rule. And because he was only breaking a rule and the chargeback was for legal costs, that does not fall within the indemnity clause. And therefore, that chargeback that condo and their lawyers did to that Mr. Imlani was invalid. Now, that case, for some reason, has taken on a whole effect of its own. It might be because there was some misinformation out there that was published by the CAO, the Condo Authority of Ontario. I don't know what went on, but for a couple months or a few months after Imlani came out, a lot of people started arguing that a condo cannot charge back at all without actually getting a court order to allow them to do so first. Because in Imlani, the court said you can't just charge back condo, you have to get a court order first. Now, the Superior Court subsequently has now clarified that that Imlani case does not stand for that. That Imlani does not stand for the proposition that a condo can never charge back. It merely says that the condo's declaration's wording of the indemnity clause has to be expansive enough, has to be strong enough and capture what actually is being charged back here. So in Ottawa recently, there was a case called O'Regan, and it was basically a case where the individual resident left some eggs burning on his stove, and that stove, I guess, caught fire, and the fire caused physical damage, smoke damage to the hallway. And so because of that physical damage, that condo's indemnity clause, which also had that whole to or with respect to all other units or common elements, that kind of wording, it still applied, because in that case, there was actual damage that was being charged back. It wasn't just an airy-fairy legal cost for rule breaking. It was actually a physical thing that happened. So because of that distinction, the O'Regan case then distinguished from Imlani and said, look, Imlani does not apply here. We can still, or the condo can still charge back without a court order. And so that's why I think in the very beginning of this, when Richard asked the panel question, when can a condo write off the common expenses? My answer was it depends. Sometimes we see some managers or some boards come to us with a chargeback that they've already levied, already added to the unit's common expense ledger, and have already threatened to lien. And we have to tell them, look, your indemnity clause does not cover this specific incident. For example, if the guy was only making noise or smoking and there's no declaration indemnity clause that applies. The newer condos nowadays do have an expansive indemnity clause. So I see most of the time this issue comes up in older condos where the condos declarations were drafted pre, I'd say 2001, where a lot of the condos declarations only had either limited indemnity or no indemnity at all. So you really do have to check your declaration, check with your lawyer to make sure that that specific condo's declaration will cover you if you do charge back for something. And so the other thing, I guess I'll mention this later, but when Richard talks about the timeline to lien, I can talk about how O'Regan actually also helps clarify something for us regarding the timeline and when the 3-month window starts. But back to you, Richard, for now.
All right, thanks. I want to stress, I look at Imlani and I see bad facts make bad law. If you were to second guess, look at Imlani in hindsight. You've got an individual that did everything to try to cooperate with the condo, and the condo just, again, this is how the court portrayed it. The condo did everything to hammer him, and then they tried a creative interpretation of the indemnity. It was really unfortunate because it turned on the wording of the indemnity, as Victor, you said, it was a property damage indemnity. But the court at some point in Obiter said, you got to get the court order if you want to charge back. And that was really unfortunate because it just put a lot of mud in what was a fairly clear, clear practice, clear interpretation of this law. So I'm really thankful O'Regan came up very soon after and clarified that. One other thing I wanted to just say about chargeback, and that goes to bylaws. And I realize as Victor was speaking, we actually draft something into our bylaws, which I'm hoping will get around a little bit of this, which has to do with third-party costs. You have to tow somebody's car or something like that. It's, nobody can suggest it's a subjective cost. And we drafted a provision which allows the condo, or which purports to allow the condo to apply regular common expense payments to pay that third-party cost if there's a link, which would thereby create a shortfall on regular common expenses. Hasn't been challenged yet, and I hope it never. Well, if it ever is, I hope it does stand up. It's logical, at least in my view. So the timeline, very important. I've just taken 5 months randomly, just happened to start with the beginning of the year. $300 a month common expenses. And assuming that the owner misses, doesn't pay January, I want to stress, I said this right at the beginning, the statutory lien starts then. As soon as that's missed, statutory lien just happens. Don't have to do anything. But if you are asked for a status certificate, you want to make sure that status certificate is updated to reflect the arrears. Now, when we think about best practices, what you want to think about Section 17 sub 3 of the Act, which says the corporation has the obligation to take all reasonable steps to effect compliance, and collections is a compliance matter. So that going towards reasonableness, I really like reminder letters. They're not mandatory. The Act doesn't say anything about doing them. But if you ever think about, I had a principal lawyer when I was just starting out. Senior lawyer told me, for everything you do, imagine it's going to end up in court. How is it going to look? And I love reminder letters, because if you take every step to spell out to the owner what's going to happen, what is happening, give the owner every opportunity to make payment, well, then you can get before court and say, we tried, judge, we tried. But the unit owner left us no option but to escalate. All right, we didn't want to, but we were left with no option. And that's really where reminder letters go, in my view. If you're doing a reminder letter, there's no set form, obviously. First one you can do very friendly, like it should be in writing, always in writing. You need the paper trail. If you get to the second one, I think it's important to ensure that it's addressed to the owner, not generically to the occupant, and reflect. If you've got other names, like to the bank, to anyone who's got an interest in the unit, include it. And why do I say the bank? Because chances are you'll get a complaint about defamation or whatnot with respect to title of the unit. Because as soon as the arrears came up here, as soon as that statutory lien started, it put the bank in default, the mortgage in default. So the bank's got every right to know. Address it to the owner at whatever address you have in the register. Reference the specific unit that it applies to and put down the cost ramifications. All right, so all legal costs could exceed $1,000, could very easily exceed $1,000, but put it in there. Again, if it goes to court, you can say the owner knew everything. So then we get to the spot where we have to start thinking about perfection of the lien. The lien is statutory, starts automatically. And there's this 3-month window. All right, we always think about a 3-month window. And I once had someone come to me who said, well, the lien doesn't actually, you can't register until after 3 months. Right? Dead wrong. Dead wrong. The statutory lien is automatic, but you have to perfect it by registration of the lien within 3 months. All right, once you go outside of that window, you lose something. All right, so if we, on this timeline, if we didn't register until sometime in April, January would no longer be secured under the lien. Excuse me. So it's important to recognize when the statutory lien stops. And here it's before April, so March 31. So we have to say, what is the legal process? And it is a legal process. The courts have recognized this. The legal process starts with the issue of the notice of lien. Used to be called, back when the current legislation was introduced on May 5th, 2001, it was called a Form 14. And a lot of people still refer to it as that, but the proper name is a notice of lien. So that's got to be issued. That's a prescribed form. With respecting the legal process, who are all the various parties? You've got the owner in arrears who can't pay. You've got the condo that needs the cash. You've got all the other owners. If that owner doesn't pay, all the other owners are putting the bill. In a small condo, that's huge. And then you've got third-party interests like banks, estranged spouses, etc. Fabulous tool, but it can be compromised if that legal process isn't followed. So the notice of lien, it's a prescribed form. Don't mess with it. All right, you'll always hear me say, prescribed form, don't mess with it. All right, you shouldn't be, but they do get messed with. Don't. There's other ways. So common problems with it. Service. The Act only says send it by regular mail. I'm going to encourage you to also send it by registered mail. So regular and registered. I think the cost difference is what, about $10? I forget what registered mail is going for right now. But the thing is, with registered, you get physical evidence that you mailed it out. Wrong or missing name. I'm going to get back to that. Wrong legal description. You've got to put all the units, the legal description of the unit. Every unit in the condo has a unit number and level number. It's got to be correct. This is not to be mistaken or confused with a municipal address. And when these sometimes we receive these and all they have is a municipal address, and I cringe because it's not right. Including too much as secured under the lien. And the wording here, the condo notifies you that it has a lien. And as I just mentioned, there's a 3-month limit on what you can secure. So the total right here is limited to 3 months. Wrong or missing interest component. Interest is taken from the bylaws. And again, if your interest rate is low, or if it's missing, so don't have it, amend that, put in an amending bylaw and get that put quite high. Incorrect due date. It's got to be at least 10 days before the lien is registered. Whenever you see the words at least, traditional view was you added 2 days. More recently, we have, I forget the name of the act, Victor, you can jump in because I know you know it, and you add 1 day now. I always work towards 2. I like to be conservative in this. And then here's just a practice, best practices. You can't mess with the Form 14 with a notice of lien. It's prescribed, but you can add a covering letter to it. And the covering letter can fill all the gaps. If you've got unsecured arrears, you can deal with it. You want payment by certified check or money order, you can deal with that. And you do want payment by certified check or money order because of the tight timelines to perfect. So you can do all this in a covering letter. And here's a practice tip. If you get somewhere near the end of that 3rd month and you realize you have this uh-oh moment that wakes you up in the middle of the night and you realize you haven't issued the notice of lien, still get it out before the end of the month. And the reason being is you can reflect on it the full arrears. If you wait until April, you can no longer reflect January on it. There's a case out there, I forget the name of it, and I don't like it, which says the form for the notice of lien is it's not a forward-looking document. It's a backwards-looking document, and it suggests that come April you have to reissue it. I'd love to see that case appealed sometime because it's harsh on the owner. So practice, just practice advice. If you get to the end of the month, get it out regardless. So I mentioned about having the right name and address of the owner. It used to be, if anybody remembers when the notice of lien first came in, was first required, and this goes back to 2001. Before 2001, there was no mandatory pre-notice of the lien. All the act said was you had to notify the bank, not even the owner, on or before the day you registered. 2001, the notice of lien was introduced. It was introduced as a low-cost warning letter to the owners, and you would send it to the name and address that shows up in your register. It was logical because the act also put the onus on the owner to give you the proper name and address. A few years back, they amended the act, and they said the owner means the person who is shown as the owner of the freehold interest according to the records of the Land Registry Office. What does this mean? It means that the low-cost warning letter is no longer a low-cost warning letter. You've got to do a title search. I'm going to get into a case that stresses this. Oh, sorry, one more thing. If you're worried about the cost implications of doing the title search at the notice of lien stage, put more emphasis on those voluntary warning letters. We're back to that. We're back to how it was before 2001, where reasonable practice were the voluntary warning letters. And again, it's a great way to go. So what does this look like now? Well, we've got the statutory lien starts and we go 3 months, notice of lien goes out. We now know that we have to search title. And when we search title, we're going to find out not only the name and address of the owners, we're also going to find the name and address of encumbrances, of guarantors, of other interests. Could be an estranged spousal interest. And then we know that this has to go out by regular mail, but also send it by registered. And what we've started doing is we now send it, because all of this information comes out with a title search, we've started sending this notice of lien to everybody we find at this earlier stage. And the results have been quite phenomenal. We're clearing up about 70% of files before the lien is registered. So it's better on the owner who's in arrears because the costs are lower. You miss out on the registration and discharge fees. It's better on the condo. Condos paid up quicker. Better on the community because they're paid up quicker. And for the bank, if the third party interests, if they get involved, there's less at stake. So very much worthwhile. The case that brings all this to light came out in 2019, Shingen and Carlton 203, another Ottawa case, lots of Ottawa cases recently in recent years. And what it was is there was a spousal interest. An estranged spouse had registered a claim on the matrimonial home, but it only showed up as a notice. If you took a quick look at the unit page, it only showed up as a notice. You would have to pull it to see what it was. And the court ultimately held that she had full right to notice from the notice of lien stage. I think that's a bit extreme, but again, to think where this case ended up before the court made that ruling was quite incredible. So they took it right back to that stage. So be efficient, include everybody at this early stage. You have all the information is available if you've got it on hand. So just instead of just sending the notice of lien to the owner, include it and send it to everybody. It's very little extra work. Perfection of the lien. This is what we've been working towards. Very exciting stuff. We want to be perfect. And what perfection means is we're actually registering the lien at the land registry office, assuming we've done everything else correctly. And the act says we've got to send notice to the bank or to any encumbrances on it before the date it's registered. If we've already done that, then really all it is a very quick process of searching last instruments and pressing register. It's that simple at the end of the month. And another benefit of sending out notice early is you lose the backlog at the end of the month. If you haven't sent out notice to encumbrances, et cetera, at the Form 14 stage, search title before registration, then you do have to do it. And this is registered mail as well. And you're then going to also update your status certificate because the lien is now registered. After registration, what happens?
Before we go into that, Richard, did you want me to talk about the timeline? I saw a question in the Q&A about the timeline for perfecting.
Go for it.
The window, basically. Okay, so as I mentioned before, and I do see a question in the Q&A about this, when does that 3-month period start? So number one, I think I always say this to all my clients, it's not 90 days, it's 3 months, 3 calendar months. And that's important because February, as you know, does not have the full amount of days. So do not count 90 days, count 3 months, because under the Condo Act, it's 3 months, not 90 days. So the 3 months starts kicking at the default date. And the question has always been, when is the default date? Because that's very important to know whether the condo has registered the lien in time. And so basically the default date is the date that the unit owner has failed to pay their common expenses. It is not necessarily the date that the repair invoice came in. It is not necessarily the date that the condo paid the repair invoice. It's not even the date that the unit owner has been told that they're going to be charged back. It's the date that the unit owner has to pay that charge back. So a lot of managers do a warning letter, a sort of heads up letter. There was a flood that resulted from your unit. we're going to charge you back for X amount of dollars. Here's the invoice from the plumber. The date that the manager puts into that letter to demand that that person pay that invoice for the condo or to the condo so the condo can then forward that money to the plumber, that payment deadline is the relevant default date. So it is, again, not the date that the condo gets the plumber's invoice. It's not the date that the plumber gets paid by the condo. It's the date that the condo gives to the unit owner to pay a amount of money that they are owing to the condo for a valid chargeback, basically. So you have to remember, again, not the date that you either get the invoice or pay the invoice. It's the date you tell the owner that they have until to pay. So your demand letter, let's say February 1st, says we got this invoice in January for a flood that happened over Christmas. Here's the invoice, paid by February 15th. February 15th is the relevant date. So if they don't pay by February 15th, then either the 15th or the 16th, depending on how you word it, is the default date, and you start counting 3 months from February 15th or 16th. That is the 3-month window. That was discussed in O'Regan. It's part of the case law. It's been part of the case law for many years. But in O'Regan, that case that I just talked about earlier, that is something that the court dealt with. And that's exactly what happened. The smoking damage invoice was informed to the unit owner, to Mr. O'Regan, that, hey, we're going to charge you back for the smoking damage invoice from the remediation company. But they gave him until March 1st to pay. They gave him the invoice back in January. They gave him 30 days to March 1st, essentially. And so the condo didn't register until 3 months after March 1st. And the Superior Court in Oregon said that's fine because the default date is the date that the deadline was missed by the unit owner. The other question I get a lot is it the default date if we add it to the unit ledger on that date? So for example, you give the unit owner till a Friday to make payments of the plumber's invoice, they don't, but the manager doesn't get back until Monday, and management doesn't add it to the unit ledger, the actual ledger itself, until the Monday. The default date should be the Friday. I've gone to court and I've won on the default date being the invoice, sorry, not the invoice date, the alleged unit ledger date where you added it to the ledger. The difference was only a few days, so it wasn't too important. But to be super safe, I always say to people, don't use the date that the unit ledger was added to. Use the date that you gave the unit owner to pay that amount. Okay, if there are any other questions regarding that, please feel free to put it in the Q&A. And then I'm going to hand it back to Richard.
Yeah, just to add to that, Victor, if they don't put any date in, does it leave it open?
It does, but I always say you should probably do it within a few months, because a judge, we've had judges before say, well, you guys waited a long time to charge it back. It looks weird, basically. You legally have, technically speaking, up to 2 years to do it, but I don't want to go to court to a judge and say that a year has passed and they didn't add it to the unit ledger or tell him that he has to pay and they didn't charge it back until a year later. So we're here now, Your Honor. So I always recommend do it within at least a few months of the invoice being received and paid. Because again, it's a cash flow issue too, right? I mean, the condo is going to want to get that money. So do it within at least a month or two, I'd say.
I want to stress, from my perspective, running these files, I want the file to be as clean as possible. So if I see a demand letter with no date, or even worse, a series of demand letters and none of them have dates, again, I'm cringing a bit. I'm worried about a challenge. So Victor, if somebody's got puts a deadline date, can the next letter extend the deadline date? Yeah,
that's happened to me before in a few of my files. I always phrase it as the condo's being nice, basically. We're trying to give them more time, especially during COVID, especially with some difficulties with income people have. So I do try and characterize it that way, but I would not recommend it. Stick to the original date, because it doesn't hurt to lean early, to be honest, right? You can always lean and not enforce. As long as you have a valid chargeback and you've done the notice of lien. So I always say be better safe than sorry. Treat the 3 months as starting as early as you think it should, as that first missed deadline, basically. If you're going to extend, that's fine, but keep in mind in your internal calendars that you have to notice a lien and lien within the 2.5 and 3 month dates. So in your internal calendars, mark it off, but you can always tell the guy you can pay next month and we won't actually lien you or notice a lien you until 2.5 months after the default date, basically.
Yeah, I'd go even go stronger than that, and point out that chargebacks are usually bigger than monthly common expenses, sometimes massively so. Just thinking in insurance deductible being charged back now, massive compared to monthly deductible. I am not, for me, I don't want to take any risk with that. And I don't think any manager or any director should be taking on any risk. If anything, I want to minimize the risk. I actually like to start the legal process of perfection a month early, just in case something goes wrong. That's how paranoid I am on these.
Well, you're taking
yeah.
a risk that we're going to be off time here because I need you to get back to your presentation.
Okay, yes, dear. Moving on.
Oh, there it was. Yes, dear.
Okay, after registration, acceptance of part payments. You have to accept part payments. There's a case went to court a few years back. The court looked at the interest rate. Yes, I do push high interest rates, and they looked at the high interest rate and said the interests of the owner are not being respected if you don't accept part payments. If you receive full payment, you're obligated to discharge. This didn't exist before 2001. That's why we sometimes see old liens still on the books. But post 2001, the condo had the obligation. So if you see a lien on the books that was registered, say in 2002, and everything is clear, the condo's got the obligation. Somebody messed up, and that's got to be discharged. So in practice, if a figure gets put out, if payout particulars get put out there and they get paid, you're obligated to discharge. So if the file is with the lawyer, do not put out the figure. All right, if it's a staff certificate you're referring to, unit is in arrears, contact XYZ law firm for payout particulars. Do not put out a figure yourself, because chances are you'll make an error with respect to legal costs, interest, etc. At that point, the lawyer's managing the file. It does happen. It shouldn't, because the condo, if that gets paid, the condo is going to have to discharge. If still after registration, we typically do 3 reminder letters now. One of our COVID adjustments, we used to only do 2. And then there's power sale proceedings you enforce in the same manner as a mortgage. Now, all of this takes a bit of time. And you think about it, 90 days to set up the registration of the lien. Then we've got the reminder letters. We typically do these a month apart. Then you got the power sale notice, which has a 45-day redemption period. You're in the latter half of the year, before you're starting the actual possession, should you need to sell the unit to recover. But it's still a lot faster than any other way of doing it, and a lot cheaper as well. So be accurate, be consistent, be reasonable. The process is fabulous when it's not compromised. It really works well. A summary of requirements and considerations. The reminder notices are considerations, but they are a really good idea. They go to reasonableness. Who the owner that gets it? Land Registry Office. That's a requirement. 3-month limitation requirement. Part payments requirement. Mortgagee rights. Discharge of a notice to the owner requirement. Staff certificate update as a requirement. A torment of rents. This is the first time you've heard me say that today. I think in the last 20 years, I've done about 3. I find a torment of rents is when if you've got a tenanted unit, you send notice to the tenant, say pay us your rent. We're going to apply it against the common expense arrears. It sounds great in principle, but what invariably doesn't work is, first off, it's very inefficient. You got a series of part payments. That's not how we're set up to work. And the files I've inherited on this have typically been a bit of a mess as far as record keeping. The bigger problem is when you send notice to the tenant is going to say, no way. Why would I pay you? I pay my landlord. I don't want to be in default of my lease. And then you're into another fight. And yes, you can take the tenant to court. You can get the order. You can terminate the tenancy. But all of that goes towards cost and efficiency. Doesn't work. Where I see a torment of rents as working is if you've got unsecured arrears, i.e. you lien too late. Doesn't extinguish the debt. And basically your torn rents bring in those part payments if tenant pays until everything is secured under the lien, and then go forward. Summary number 2, recognize the legal process and all the parties, the owner of the condo, the other owners, and the third parties. Don't compromise, because you don't want to go to court. You don't want to be fighting over priority. You don't want to spend money that can't be collected, and those are unreasonable. Legal costs cannot be collected. And of course, you don't want to write off the debt. Some COVID ideas. There's a lot of talk a year ago about payment holidays, creative agreements, etc. Doesn't work. And the reason it doesn't work is because you've got to bring in all these parties if you're going to have any chance. Besides the fact it contravenes the act, you can't contract out of the act. But if you just have a creative agreement between the condo and the owner in arrears, where are the interests of these parties? They're not there. And that's where you're going to have problems. What I really like are the warning letters, the reminder letters, just beefing that up, bringing in the mortgagees as early as possible. We actually right now ask the banks to pay it forward. We had one the other day actually pay the balance of the year in common expenses, and it gets rid of the problem. Hopefully, the economy's back up. The owner's is not in financial difficulty by then. But the banks are in the practice of lending money, so better on them. The interest rate, there's nothing that stops the board from saying, I'll accept a lower amount in interest. Reduce hardship, but you got to get payment. Post-registration protocols, again, we've changed that to do 3 reminder letters now. And then augment indemnities. Victor alluded to this in the Omlani decision. There's a whole bunch of condos with no indemnity whatsoever in their declaration. You've got property damage, insurance deductible, compliance costs. We're now drafting in successful defense cost indemnities. You want to have all this as much as possible in the declaration. Trish, do you want to go into the frequently asked questions, or do you want to just deal with other questions, or how do you want to go forward?
You can go ahead. It's all right. They're logical questions, so.
Okay, so
we'll go for about another minute on this because we have John, and then we would like to take a few questions.
Okay, so what can be charged back? How do we find out if we're not certain? Victor, I'm just going to summarize if you don't mind on this one. You got to find the authority in the act or the declaration. Victor went through the Omlani and O'Regan cases. There's also the Italiano case. If you're not certain, call your lawyer because there's no point doing, or you can basically get an opinion on it. It's really unfortunate, but we see a lot of chargebacks come in compromised, and then we're creatively trying to make them secured. Are arrears over 3 months uncollectible? Can they be made new again? It's still a debt owed by the owner to the condo, and the problem is they're not necessarily secured under the lien. Can they be made new again? I would love to shout out a case that we were successful on way back 2004, York 298 and Knight, where we approached it as a compliance matter. And we got the order from the court that the owner was in breach of their duty to pay common expenses. We got recovered full costs under 134 sub 5, and everything was great. What we didn't do was we didn't go after super priority, all right, against the bank. And unfortunately, in 2017, somebody did. TSCC 1908 and STEFCO, the only issue was priority over the bank. And when you look at it, if there are unsecured arrears, the condo's messed up. The owner's messed up. The bank hasn't done anything wrong because the bank doesn't know about it. So bad facts, bad law, and unfortunately, the 298 and Knight case is no longer good law. Really a shame. Who should drive the collection process, and what are reasonable legal fees? John, there's a case here for you.
What are reasonable legal fees? Do you want me to jump into my my points now?
I would.
Excellent. So thanks, Richard. So we've heard a lot about what the purpose of a lien is, what it does, and how it can be effective, and how legal fees are incorporated into a validly registered lien. And when you have the validly registered lien, you've got, as a unit owner, 2 options to deal with a lien. You can either pay it, which is often the most common sense approach, and if there's really no dispute over the lien, the only approach that should be taken, or you can dispute the lien. And the disputing of a lien drives costs up exponentially for all parties. And the question's always going to be, well, if we have to spend money fighting this lien or fighting this dispute over the lien, is it better just to pay off, to forgive the lien if we're going to spend double or triple what the actual lien amount is, if it's a few $1,000s, maybe even more? Should we just forgive that debt, move on, and save the legal fees? And my answer to that is no. If a valid lien is disputed, Section 85 of the Act and the court has upheld this provision to say that a registered lien secures all the reasonable legal fees and reasonable expenses incurred by the corporation to collect that lien. So when you consider the fact that all reasonable legal fees can be recovered and a valid lien holds those fees and secures them, it's an absolute disaster situation for the unit owner who chooses to dispute a valid lien. And that's exactly what happened in the case of MTCC 868 and Pang. And Ms. Pang was a unit owner who, for whatever reason, decided to stop paying her common expenses. And she stopped paying them in June of 2018. The condo waited a few months. She didn't pay. They registered a lien in January 2019 after 7 months of non-payment. In May 2019, the condominium corporation then brought an action to secure the vacant possession of the unit. And subsequent to that, they then brought a motion for summary judgment to say to the court, we don't need a full trial for this. The facts are fairly simple. We don't need a trial, no triable issue. The night before, shortly before the summary judgment motion, Ms. Pang actually agreed to pay the amount secured by the lien, which is $21,000, to secure really a very small amount initially, ballooned to $21,000, plus $4,000 worth of interest. Sorry, including $4,000 worth of interest. That amount was agreed to. The problem for Ms. Pang was the condo corporation also wanted to recover $56,000 in legal fees. When you look at the two numbers, $21,000, we need to collect that. But there's $56,000 that we've paid in legal fees to actually try and prosecute this lien. You know, any judge that looks at that's going to raise an eyebrow and say, oh, no, those numbers look a little bit skewed. And the unit owner made that argument to the judge. He said, we agree that $21,000, we agree on the common expenses, we agree on the interest, but we don't want to pay the legal fees. The legal fees are unreasonable. So the court looked at this matter and said, well, you know, Ms. Pang commenced a counterclaim against the corporation. It was meritless. She tried to claim there was damage to the unit. She tried to claim that she actually paid these common expenses despite knowing that she hadn't paid them, driving up the costs. So the court actually turned around and said, we're going to award the condominium corporation its full costs. But they noted that while the fees could be high, the use of the phrase all reasonable legal costs in section 85 sub 3 of the Act signals that the condo is entitled to more than what we call partial indemnity costs. So more than about 40, 50 or 60% of their legal fees. And that the condo is entitled to recover all the fees it incurred trying to enforce the debt owed by Ms. Pang, so long as those costs are reasonable. And the court looked at what reasonableness was. It's while the legal fees claimed are high, particularly when looking at the amount that was initially unpaid, they are reasonable for several reasons. And Ms. Pang, she chose to withhold her common expenses payments throughout the litigation. She vigorously defended the condominium's valid claim for lien. And the court also looked at the fact, well, not only was her defense devoid of merit, she can't complain about the cost because her legal strategy was to vigorously defend it and put the cost of the defense on the innocent unit owners who had no part to play in this. So the court incorporated the innocent parties who pay the common expenses, who paid their common expenses, and who, if the court reduced the legal fees, would then be expecting the unit owners to carry the rest of the burden there. And we heard Richard talk about reminder letters and reasonableness. And the court looked at that and said, well, you know, Ms. Pang also had all these other opportunities to settle this matter before the condominium corporation incurred significant legal costs. She could have settled this matter when the lien was registered in January 2019. She could have settled it after the service of the statement of claim. She could have settled it after, you know, in between the actual service of the claim and the motion for summary judgment. But no, she waited until the last possible minute. And that was entirely her litigation strategy, and she was penalized for it by having all the costs awarded, including the interest, put at her feet, and she was required to pay it. The court has basically found that Ms. Pang cannot now complain that the condominium incurred legal fees, especially given the fact that her efforts to settle were reserved until the very last minute, basically on the eve of the hearing. So my takeaway for that is really that lien proceedings, although they can be expensive, although there may be an outlay of legal costs, that if all the steps have been taken and the lien is validly registered, the corporation will be entitled to all its legal costs. Thank you, Richard.
Thanks very much.
I have one other case. I can jump into it really quickly, but I'm sure people have questions. So Patricia, Richard, in your hands.
Well, I think
Patricia.
we're at 1 o'clock now. And so I think what we should do is, if we have any questions, there was a question in the Q&A box. There were two questions and I can't see them anymore. I'm not sure if they were answered.
Yeah, I answered
So,
them in writing just in case we ran out of time, but they are in the Q&A box if you look at the answered tab.
okay, great. Thanks, Victor. So everybody keeping us on time. So what I think we should do then is, John, since you did prepare the last case, could you go through the last case for me, please?
Yeah,
And then
very
we'll
quickly.
wrap up. Thank you.
Excellent. So the last case, just to touch on what Shannon was talking about and what you've probably heard a lot about on our CondoWise updates, is the pandemic update. This case was recently released. I believe it was on Wednesday of this week, and it was CCC 32 in Yakovlev. And CCC 32 was a residential condominium corporation, had 177 residential units, and they had some unit owners who were noted to have been not wearing masks on the common elements. And that wasn't really disputed. The respondents' own evidence led the court to a conclusion that they weren't wearing masks on the common elements. They didn't allege a medical condition. They didn't really dispute the fact that they weren't wearing or observed not wearing masks, and they admitted that bylaw had been called on a number of occasions to deal with their lack of compliance with the municipal bylaw, and it even issued warnings to them. So very simple facts: not wearing masks, not contested. But there was another set of issues: excessive noise coming out of the unit, some allegations of harassment, and some other things. The condominium corporation went to court on an urgent basis and asked for a number of orders requiring compliance. And one of those orders was to require compliance with the mask bylaw. And the court said, yeah, the condo has the obligation under Section 117 of the Act to prevent dangerous conditions. And the court said on that basis, the failure to wear a mask creates a dangerous condition and constitutes a risk to the health and safety of the other residents and staff of CCC 32. And eventually the court ordered that they cease and desist from traveling on the common elements and permitting the authorized occupants of the units to travel on the common elements without wearing a mask or face covering that was contrary to Ottawa's mask bylaw and the corporation's COVID-19 protocol. Previous to this decision coming out, there was another decision that was released, I believe, in March, and it was HCC 77 in Mitrovic. And in that particular case, there was bad facts for the bad law created by the judge. The court actually said, well, you know, they've alleged the medical condition. The municipal bylaw doesn't require or prohibits the asking for evidence of a medical condition. And on that basis, although they've said they have a medical condition and they haven't really provided evidence of a medical condition, I'm not going to require them to provide actual evidence of a medical condition. But what I will do, the judge speaking, what the judge did do is order that the respondents in this matter wear masks for ingress and egress from their unit in the corporation, but required them to wear masks on other areas that weren't required for ingress and egress from the corporation. So I know my colleagues have a very dim view of this judge's decision. It doesn't make a lot of sense. It doesn't really deal with the fact that not wearing a mask creates a dangerous condition and seems to condone not wearing masks. And the one thing I forgot to mention was that the respondents in this particular matter were actually anti-maskers, for want of a better term. They carried propaganda about not wearing masks. It seems really to be set up to say that they didn't have a medical condition and they just hated the idea of having to wear a mask. Nonetheless, the court said, no, we can't force them to provide medical evidence. So that's out there. We don't necessarily agree with it by any means, but it is out there.
Thanks so much, John. I appreciate that. And I'm going to, just share a little bit of my view on this, that when you're managing the risk in a condominium, especially if you're a workplace and you are for OHSA purposes, you need to think about not just the person that is refusing to wear the mask, but the risk that that person creates in terms of informing your community, making sure that the common elements are clean. The one thing that I find very myopic and really not based in any scientific evidence in this case is how the virus is transmitted. And I'm not sure if you enjoy lockdown. I really don't like it. So I would really like to see this all come to an end. We all need to take the necessary steps to ensure that our communities are safe on both sides of the mask. The mask is for the benefit of not just the wearer, but other people. So I would ask you to really think that through, share information on how we can actually get the vaccines out to those who want them. I would like to thank all of our speakers. Richard is one of the few people who loves the condominium lien process. And Victor and John, thanks for backing him up so much with the case law and keeping us current. Shannon, thank you as always for the updates. Caroline, although we can't see you, thank you so much for keeping us all moving. As well to all of our participants and our members in the audience, thank you for your questions in advance. Thank you for being here. I'd like to wish all the mothers happy Mother's Day. If you have a mother, please make sure you show your appreciation in some way. Stay safe, wear a mask, wash your hands until we get through this. But again, to everybody in the condominium industry, thank you for your hard work during this hard time. Stay well, and we'll see you at the next CondoWise session.